The Lindt Gold Chocolate Bear has been saved from destruction thanks to a recent ruling of Germany's highest court. Haribo, a confectionery maker most well known for its gummy bears, sued Lindt, alleging that Lindt's Gold Chocolate Bear infringed its trademarks, the words Gold Bear and Gold Bären, meaning Gold Bear and Gold Bears respectively, as well as Haribo's 2D image mark of a yellow bear. Haribo claimed a wide range of remedies, including damages and the withdrawal and cessation of sales and destruction of all Lindt Gold Chocolate Bears. This was a significant case in Germany, as it was the first time that a court had had to consider whether a 3D object could infringe a word mark. What the court had to compare was the 3D gold shape of the bear against the words Gold Bear. The shape of the product in respect of which the marks were registered, so that is, the shape of the gummy bears, were not to be included in the comparison. Interestingly, the court said that it was possible for a 3D shape to infringe a word mark if they had a similar meaning. That is, if the word mark was the only possible designation which could be given to the 3D shape. The court noted that a strict standard applies. Otherwise, the owner of a word mark could be given a monopoly over a wide range of products. When one looks at the Lindt Gold Chocolate Bear, what words come to mind? While Gold Bear is one of the terms that could be used, it's equally just as likely you could think of the words teddy, chocolate teddy, or chocolate bear. The court said that it's not sufficient that Gold Bear is one of the many possible terms that could be used when referring to the Lindt Gold Chocolate Bear. As such, it held that the Gold Chocolate Bear was not similar to Haribo's word marks, and thus there was no infringement. In relation to Haribo's 2D image mark of the yellow bear, unsurprisingly, the court found that the two were not similar. So what would happen if Haribo were to bring the same action in Australia? Would the bear survive the same challenge? Australian courts have not actually had to yet consider whether a 3D shape can infringe a word mark. What we do know is that a 3D shape can infringe a 2D mark comprising a shape or a picture. For that to be the case, the 3D shape and the 2D shape need to be substantially identical or deceptively similar, and the 3D shape needs to function as a trademark. That is, it needs to be used as a badge of origin. For example, a confectionery wholesaler was found to have infringed Coca-Cola's 2D trademark comprising the shape of a contoured bottle by importing and distributing lollies in that same shape. The lollies had distinctive features on them, like the fluting of the bottle, the silhouette, and a band label, which were held to distinguish the goods from the goods of other traders, and as such, there was infringement. In addition, a 2D image could infringe a word mark in Australia. The Australian Trademarks Office found that a 2D image of an emu was deceptively similar to the word mark emu, which was registered in respect of wines. When we look at an image of an emu, the only name or idea that comes to mind is emu, which naturally is precisely the same idea that will come to mind when looking at the word emu. Therefore, it's possible that a 3D shape could infringe a word mark in Australia if the two conveyed exactly the same idea. So what does this mean for Haribo? Well, if it were to bring its action in Australia, unfortunately, I suspect it would have faced the same outcome.